arise. The reason I pointed this out, Your Lordship, there are different types of change in rules. If rules permit, advertisement does not say so. Rules are silent, advertisement provides for it. Rule specifically excludes advertisement. So there are 3-4 different permutations.
So rules also don't specify, advertisement also don't specify.
That's a clear cut.
Even after the written examination,
yes, Your Lordship.
Before going for Viva OC also, they don't inform the candidate. That's again the fourth category.
Fourth category. So there are multiple ways in which these rules can be changed. So our submission is rules should permit and advertisement should also specify. In that, Your Lordship, there's just this one case. There's another case where again the zone of consideration was reduced. I will not read it, but just point it out, where the number of vacancies were notified and candidates had to be called for interview. The rule was 2 or 3 times the number of vacancies will be called. So the advertisement said 750 vacancies are there approximately, but it can be changed. So 1,500 candidates had to be called for interview, double the zone of consideration. After a point of time, after applications were received, they changed it to 470 vacancies. It was drastically reduced by 300. And only 940 candidates were called for the interview. The court upheld it. This honorable court upheld it, saying that, the notification says that the number of vacancies can change. But the question arises, it says 750 approximately gives you the feeling and the belief that it will be in and around 750. But to reduce it drastically to 470, this would be a clear case where if the authorities had been told you had to give it in writing, the reasons why you drastically reduced it, it may have helped for the purpose of judicial review to see whether it was arbitrary or not. And then there's judgments, Your Lordships, I won't read it, but Suresh Kumar, Lalit Kumar Patil versus State of Gujarat, 2023. The last one. Yeah, the last one. Maybe just one last judgment and I'm done.
Yes.
It's at page 253 of this compilation Your Lordship has. Suresh Kumar, Lalit Kumar Patel versus State of Gujarat.
Page 253.
Yes, Your Lordships. Lordship, the neutral citation is 2023 INSC 145.
Very good. Thank you so much for the neutral citation.
Stay for it. He's the one who pointed
Yes,
it out.
very
He
good.
told me I should use it.
We will encourage this.
It's at page 253.
Now we are working on neutral citations from 1950 through to 2013.
From 14, Your Lordship has it.
Yes.
So we've tried to make a list of that. Para 2. The decision of the division bench of the High Court of Gujarat giving its imprimatur to the decision of the Departmental Selection Committee in reducing the qualifying marks for the post of Supervisor Instructor Class 3 after publication of the result to facilitate the inclusion of candidates constituting horizontal reservation is under challenge in the civil appeals. That is reducing a criteria. Then if Your Lordship will go to para 12. It's at 255, para 12, right at the bottom, Your Lordships. The aforesaid advertisement does not give any room for any interpretation otherwise. It does speaks about the manner by which a post has to be filled up, inclusive of a special reservation in the form of horizontal one. the power of either cancellation or amendment has to be exercised by way of an amendment to the advertisement, except in case of reduction of seats. Further, such a power has to be exercised either at the initial stage, which only means before writing the examination, or during the process, and thus giving ample indication that publishing the result would mean the completion, and therefore the declaration of selected candidates would only be consequential. Para 13. The selection committee held a meeting on 5/10/2016, proposing to further relax the cutoff marks fixed only for the candidates belonging to the horizontal reserved categories. Accordingly, the cutoff marks for general category have been kept intact. Thereafter, a subsequent meeting was held on 17/12/2016, by which the earlier decision proposed to be implemented on 5/10/16 was cancelled. The meeting was attended by all the members of the selection committee. Thereafter, if your lordship go to para 23, where the discussion starts, that's at page 258 of the compilation. Another unique feature of the present case is that the selection committee had reduced the marks to facilitate horizontal reservation by treating it as a vertical reservation. Admittedly, the rules do not provide for such reservation to be treated as a vertical one. Likewise, the rules do not fix any cutoff marks. An advertisement made pursuant to a notification binds the parties. It has got all the trappings of a statutory prescription, unless it becomes contrary to either a rule or an act. A change, if any, can only be brought forth by way of an amendment and nothing else. Such an amendment, even if it is permissible, can be tested on the touchstone of Article 14 of the Constitution of India. It cannot be introduced to give an entry to a special reservation in a case where a right becomes accrued to a candidate under a policy decision reduced in the form of an advertisement to be considered for a post in the absence of any eligible candidate from the horizontal category. It is true that a candidate may not have a vested right to the post. However, it cannot be confused with the right to be considered in accordance with law. A law which enables a candidate to get a post cannot be changed to facilitate another group of persons, since the candidate acquires a vested right to be considered in accordance with law. And thereafter, they cite another judgment we have relied on, Devan Katti's case. And then they at para 25, admittedly, in the case on hand, the appellants are entitled to get the post as per the advertisement issued. The advertisement has not been amended. It was modified on the advice of the government, though an earlier decision was taken on similar lines but wisely withdrawn. Fixing cutoff marks for a particular category has got a rationale behind it. Reducing it only for the purpose of providing employment to a particular category when others have already acquired some right would be an affront to Article 14 of the Constitution.
All right. Yes.
And the Devan Katti's case relied on says that all
The judgment in Manjushri and Tej Prakash was cited,
yes,
and they at para 29,
they differentiated.
and they say that it's not necessary for us to go into
Was to
that.
go into it.
On the facts, we do not think the said issue has any bearing.
They say it's different.
Para 930, they say the decision to reduce the cutoff marks is not based on objective criteria, namely the suitability of the candidate to the post, but for extraneous reason, that is to accommodate otherwise ineligible clients. So actually the judgment can rest on this instead of going into any broader aspects of the judgment. Really.
Yes, Your Lordship. I'm obliged. So
Thank
we've
you.
given as many judgments as we think is
Thanks.
necessary.
Thanks. Not in this. Sure.
Yes. But I filed an additional
Filed something rather.
additional written submissions, my lord, but I filed the main one in the Kerala matter. So this is the additional written submissions which are there in the drive, my lord.
Your written submissions, right? Additional.
It's named additional written submission. I think my office sent a Word document. I'm sorry, it's a Word document.
Additional written
Yes,
submissions, yes.
So folder called final notes for 18th and then additional written submissions. My lord has got that. My lord has got that. I've got one hard copy. Hard copy. Just give one.
You are that additional written submission, right?
My lord has got that.
Just 1 minute.
Yes.
Petition, Thara 6. Yes, sir. इसमें पढ़ने इसके.
Before I read, can I take just 2 sentences before I
Yes.
start reading the note? The note is, my submission is twofold. One, this reference is on the context of Tej Prakash, my lord.
Yes, yes.
Tej Prakash doubts Manjushri on 2 grounds. One, Tej Prakash assumes in para 12 that Manjushri says if there is no minimum cutoff, then the 10 best people, 13 best people have to be appointed. With utmost respect, my lord, Manjushri doesn't say that.
Yeah.
So the first ground for referring Manjushri to a larger bench, with utmost respect, may not arise. Second, my lord, Manjushri in Tej Prakash, the second reason given for referring Manjushri is stating that Manjushri does not notice Subhash Chandra Marwa. With utmost respect, Subhash Chandra Marwa deals with a completely different situation. Now, my proposition is this, before I read the note, my lord. Manjushri deals with a situation where the selection committee fixes a cutoff mark before they get into the select list. So there is a process, the candidate has a right to be considered, but that right is curtailed by introducing a benchmark after the viva, after the written test, and therefore the candidate does not get into the select list.
Before consideration.
Before consideration. That is the issue in Manjushri. Whereas Subhash Chandra Marwa is a case where the candidate got into the select list. Once the candidate got into the select list, then the appointing authority applied a benchmark and said, we are appointing only the top 7. So there, the principle of no indefeasible right to be appointed, etc. comes only in the case of Subhash Chandra Marwa and not in the case of Manjushri. That is the difference. So Manjushri, there's no mistake committed by Manjushri in not referring to Marwa because Marwa does not deal with the situation at all. So that
Marwa was a case where the authority, after the process was over, said we'll appoint the top 7.
correct. There also, it's not like the candidate is remediless. So in that case, suppose there were 7 candidates. The appointing authority, that's the government, says I'm appointing number 1, number 5, number 7.
That is then a problem.
Of course, it can be challenged on the ground of
That's pick
arbitrary.
and choose.
Yes, ma'am. So, but this principle of changing the rules of the game, etc., does not arise in that case. So in Marwa, what has happened is the rules provided only one thing, which is you write the exam, you get 45%, you come in the select list. So in Marwa, after this exam, 40 people got into the select list with 45% marks, out of which there were 15 vacancies. The 15 names were forwarded by the High Court to the government appointing authority. Government says, because on the facts of that case, on the previous round, you had said 55%, High Court itself said, whatever the reason is, the government said, we are now applying 55%, and they took number 1, number 2, till number 7. So the candidates who were in that list, the 8 to 15, they said there were 15 vacancies, I was in the 45%, you should have appointed me. There the court said, no, this is not fixing a cutoff, this is the appointing authority selecting the 7 best people. There is no right for you to be appointed, therefore you have no case. So with utmost respect, so to say that Manjushri is not good law or is doubted because it did not consider Subhash Chandra Marwa may not be entirely legally sustainable is my submission. So there are 2 reasons. These are the 2.
You have your formulated.
Yes.
Let's read that.
Yes. Okay. Can I just say one more sentence?
There are 3, then you can.
Yes. In this context, this honorable court in the said reference order doubted the correctness of the principle laid down in Manjushri for the following reasons. 1, that a strict application of the principle of law laid down in Manjushri would mandate that the High Court was bound to recruit 13 of the best candidates out of 21, irrespective of their performance. 2, that the judgment of 2 judgments of this honorable court in state of Haryana versus Subhash Chandra Marwa was not brought to the notice of the honorable court in Manjushri. It was observed that in the case of Subhash Chandra Marwa, while dealing with the recruitment of district judges for the state of Haryana, it was held that the government, while making appointments from the list of eligible candidates, can fix a score which is higher than the eligibility with a view to maintain higher standards of competence. It is humbly submitted that the same is an incorrect interpretation of the ratio of Manjushri for the reasons below. 1, the judgment in Manjushri does not lay down an absolute proposition that in the absence of minimum qualifying marks, the best candidates must be appointed irrespective of the marks scored by the candidates. It is settled position of law that there is no indefeasible right of a candidate to be appointed, and Manjushri does not state anything to the contrary. 2, the decision in Manjushri arose in the context of recruitment to the post of district judges in Andhra Pradesh State Higher Judicial Service, where after the written examination and the interview were concluded, the subcommittee of the full court introduced the requirement of minimum marks for the interview, and as a result of the same, the candidates with higher aggregate marks were kept out of the merit list based on their marks in the interview. The principle of law that rules of the game cannot be changed once the game has been played was laid down in Manjushri and was applied at the stage of preparation of the merit list during selection before the said list were sent to the state government for appointment. That is the distinction, my lord. Now 4.3. Further, this honorable court in para 33 of Manjushri categorically holds that prescription of minimum marks for interview is not illegal. It further holds that the authority making rules regarding selection can prescribe by rules the minimum marks both for written examination and interview, or prescribe minimum marks for written but not for interview, or may not prescribe any minimum marks for either written examination or interview. It is specifically held that where the rules do not prescribe any procedure, the selection committee may also prescribe minimum marks for the interview, but before the interview. In this context, it is submitted that the judgment in Manjushri cannot be doubted for not considering Subhash Chandra Marwa for the following reasons. 1, Subhash Chandra Marwa was a case where the appointing authority of the state government adopted a yardstick of minimum marks in exercise of its discretion to make appointments from the list of eligible candidates prepared by the Public Service Commission, and the relief was denied to interested candidates on the settled principle of law that there is no right of appointment in a candidate merely because the vacancy was indicated. B, the said factual situation is different from the case in Manjushri, where the criteria were changed while preparing the merit list to be sent to the state government for appointment. In this regard, this is important, my lord, reference may also be made to the opinion of Honorable Justice Owens in the split decision of the 2-judge bench of Salam Sarabjit, where it was observed that the judgment of Subhash Chandra Marwa applied only in cases where selection procedure had been completed and thereafter the appointment is denied for good reasons. Now, just one sentence to add here, my lord. In the same judgment, Justice Bhanumati's judgment, which basically in that judgment, para 25, what is said in that was a case where the marks was prescribed before the viva. So Justice Bhanumati, while dismissing the case of Salam Saradid, says, had it been a case where viva marks were fixed after the interview, the position would have been different. So the decision in that case was Justice even though the
It doesn't apply Manjushri.
it applies Manjushri. It says on the facts of that case, they are not applying Manjushri because in that case, viva marks were fixed before the interview. Whereas in Manjushri, it was fixed after. So I'll read para 30 later. In para 30, there is one line where the specific sentence is para 25, sorry. Para 20 with a specific sentence which says, had the full court met and fixed the viva marks after the interview, the position would have been different. So that is the basis for that distinction. There's no other reason why Manjushri was not applied on that reason, my lord. Now, Lordship, my lord, the next question that arose in the last hearing, my lord, was whether the Manjushri endorses Umesh Chandra Shukla. So then the question arose whether if there is a conflict, Lordship, remember last time, if Manjushri endorses Umesh Chandra Shukla, and if Umesh Chandra Shukla and Subhash Chandra Marwa are conflicting, then what do we do? That was the question. Now, my respectful submission to that, my lord, is there is no conflict between Umesh Chandra Shukla and Marwa. Umesh Chandra Shukla was a case similar to Manjushri. That was a case in which the selection committee, after the interview, after everything, before the list was sent to the government for appointment, introduced an aggregate of 600 marks for written and viva. And based on that aggregate, many people who otherwise would have been eligible to be considered for appointment were not put in the select list. So the question that Umesh Chandra Shukla is similar in facts to Manjushri, whereas Tej Prakash is similar in facts to Subhash Chandra Marwa. So in this case, in Umesh Chandra Mishra, what this honorable court held is, you have no right, you have a right to be considered. You cannot interdict that by introducing this cutoff when the advertisement, etc., did not provide for it. Even that judgment, para 40, specifically, I just read that sentence. The question whether a candidate included in the final list prepared and forwarded by the selection committee may be appointed or not is a matter to be considered by the appointing authority. So what the difference is this, my lord. One set of cases, there is a barrier created before a candidate gets into the select list. Those are governed by Manjushri, Umesh Chandra Shukla, etc. The law says you cannot do it unless the rules prescribe, etc. The second are the kind of cases where after you are in the select list, the appointing authority fixes a cutoff which was not there earlier and says, I'm appointing only 5 out of 13 vacancies, or whatever the reason is. There, the issue of change in rules does not arise. But however, like I said earlier, my lord, the candidate is not remediless. The candidate still has the principles of arbitrariness, Article 14, all that is available for him. If it can be shown that that criteria, that cutoff prescribed by the appointing authority was for any other reason, was to favor one person. One example, obvious example, which I said earlier, my lord, if they don't follow the inter se merit, if they take 157, it's a ground for arbitrariness. Or they fix out of 100 marks, they fix 99% as the cutoff, and they take only 2 people. Maybe a ground for arbitrariness. That depends on facts of each case. But this principle of change in the rules of the game after the game has started does not arise in cases of Subhash Chandra Marwa and in the case of Tej Prakash Pathak. So there is no conflict between Umesh Chandra and
now let's go to para 6 of your 6.
Yes, Manoj. Can I read 4.5 for a second?
4.5. All right.
That's only distinguishing each of them. You are saying.
Well, what I'm saying is why there is no conflict between these two, Manoj.
All right. Formulate it.
I'll quickly.
Yes. In a minute, you can read.
Yes. Similarly, there is no conflict between the 2-judge bench judgment of Umesh Chandra Shukla relied upon in Manjushri and the 2-judge bench in the case of Subhash Chandra Marwa, as is evident from the following. A. The judgment in Umesh Chandra Shukla arose in the context of an additional requirement of minimum aggregate marks, which was introduced by the selection committee after the selection process were completed for the post of so-and-so in daily judicial services. The said judgment did not pertain to the discretion of the appointing authority as in Subhash Chandra Marwa. it is specifically observed in Umesh Chandra Shukla that the question of whether a candidate included in the final list prepared by selection committee may be appointed or not is a matter to be considered by the appointing authority. In any case, the judgment Umesh Chandra Shukla refused the application of the additional requirement since the High Court of Selection Committee did not have the power to prescribe minimum marks under the rules. Now, Subhash Chandra Marwa is an authority for the proposition that the appointing authority can choose to fix a higher benchmark while appointing candidates from the merit list, whereas Umesh Chandra Shukla is an authority for the proposition that no cutoff can be prescribed by the selection committee after the selection process started if the rules do not permit so. Therefore, it is respectfully submitted that both Subhash Chandra Marwa and Umesh Chandra Shukla operate in different factual scenarios and there is no conflict whatsoever between the said judgments. Furthermore, the judgment in Tej Prakash is similar to the judgment in Subhash Chandra Marwa, since the High Court, that is appointing authority under the staff rules, decided to employ the yardstick of minimum marks for appointment of eligible candidates, and there is no conflict between Tej Prakash on one hand and Manjushri and Umesh Chandra Shukla on the other. It is submitted that Tej Prakash and Subhash Chandra deal with the situation where the benchmark is introduced by the appointing authority after the candidates are included in the select list, whereas Manjushri and Umesh Chandra Shukla deal with a situation where a benchmark is introduced by the selection committee before the candidate is included in the select list. Therefore, the principle of law that there is no